Good afternoon, and thanks for joining Washington, D.C.-based Jennifer Schaus & Associates in our Get FAR cited in 2020 complimentary webinar series. As you know, the FAR, or Federal Acquisition Regulations, is the rulebook that the federal government must follow when making purchases. Our webinar series pulls from contracting experts to explain each part of the FAR. It's complimentary and recorded. We will post all of the recordings on our website and YouTube channel, where we have over 300 government contracting webinars available for download. A special thanks to our educational partner in this series, the National Veterans Small Business Coalition Education Foundation. Please visit their website to learn more about the organization. We would also like to thank our friends at Open the FAR for their sponsorship. If your organization is interested in sponsoring the series or one part, please contact hello@jenniferschaus.com. And now a little bit about us. We work with primarily large businesses to help them navigate the federal marketplace. We work with both product and service companies as well as software firms. Our clients span the globe and include publicly traded organizations in a variety of sectors. We provide market analysis reports, contract administration, contract vehicle assistance, and more. All of our services can also be built into a training course for your team. Learn more about us on our website. We would also like to let you know about some ways to reach government and government contractors through us. We offer advertising and sponsorship opportunities through our weekly newsletter and also in our webinar series. For pricing or place an order, please email us at hello@jenniferschaus.com. And now to learn a bit about today's speaker, OJ Jowick. You can find his contact information here. And today we are covering FAR Part 43 with OJ. Thank you so much for joining us, and the floor is now yours.
Well, good afternoon, everyone, or good morning, depending on where you are. And thank you for the opportunity to present FAR Part 43, Contract Modifications. Next slide, please. I understand there will be no questions today, but contact information will be included on the slides and at the end of the presentation. Anyway, FAR Part 43, Contract Modifications, is only 5 pages in a 1,000+ page regulation. It's divided into 3 parts, and the basics are it discusses what contracting officers can or must do in some cases concerning modifying a contract, either through a formal modification, which can be unilateral, requiring only the contracting officer's signature, or bilateral, requiring both the contracting officer and the contractor to sign. And change orders can be handled as a change order or as a formal contract modification. We'll also cover contractor notifications and forms. Next slide, please. So 43.000 covers the scope of the part. 43.1 is just discusses modifications and changes in general, definitions, the policy, types of contract modifications, notification of contract changes, the regulation concerning the availability of funds, which concerns the contracting officer and the contractor, because the contractor should know how much funding is available for any changes or modifications that the government is making, and the changes contract clause. Next slide, please. Subpart 43.2 covers change orders in general, covers the authority to issue change orders, the change order accounting procedures, administration, and the specific contract clauses. 43.3 basically covers the forms. Next slide, please. So diving into the scope of Part 43, it generally applies to all federal government contracts, except for certain contract modifications for extraordinary relief, which you can find under FAR Subpart 50.1. And these are modifications to facilitate the national defense. So we don't run into these very often. Also, it's important to note that task or delivery orders under an indefinite delivery, indefinite quantity contract are not considered contract modifications or changes. They just become incorporated into the contract and hopefully have been priced in advance. But because IDIQ task orders and delivery orders are considered contracts in and of themselves in their own right, the government can make modifications or changes to task orders or delivery orders. Next slide, please. An administrative change under 43-101 is defined as a unilateral change in writing that does not affect the substantive rights of the parties. And this is kind of a nebulous term. What are the substantive rights of the parties? They can include things like pricing, most importantly, probably, or rights and obligations on either side, whether it's the government side or the contractor side. And we'll get a little bit deeper into that as we go along here. Another important definition is the effective date. The effective date of a change or a modification depends on the circumstances. For an amendment to a solicitation, a change order, or an administrative change, the issue date is the effective date. So the date that the contracting officer signs the amendment becomes the effective date. For a supplemental agreement, and we'll discuss a little bit more further on what that actually means, the date agreed upon by the parties. A supplemental agreement basically is something outside of a change or modification, but related to it, that that stems from that modification or change. For example, an equitable adjustment would be a supplemental agreement. So that effective date would be the date that both parties, or the latest date that a party signs the supplemental agreement. For a modification that confirms a notice of termination for convenience, is the same as the effective date of the initial notice. So in a termination for convenience, what usually happens is the contracting officer informs the contractor that the government intends to terminate the contract for its convenience as of a specified date. So let's say the date that the letter goes out is October the 15th. The contracting officer wants the contract terminated October the 30th. The effective date would be October 30th, and the contracting officer would follow up with a formal modification terminating the contract for convenience. For a modification that converts a termination for default, which we all know is a bad thing, to a termination for convenience, which is a less bad thing, it's the effective date of the termination for default. So in that case, what happens is the contracting officer sends out a notice on, let's say, October 15th again, saying, we intend to terminate the contract on October 30th for default because you, the contractor, have not performed properly, or for whatever reason. The contractor then gets in touch with the government and negotiates changing that to a termination for convenience so that it's not dinged on past performance in future procurements. The government and the contractor negotiate a conversion from a T for D to a T for C, but the effective date of the modification converting the T for D to a T for C still remains October the 30th. Or actually, it could actually be the date agreed upon in any supplemental agreement. There's a little twist there. If there's a modification that confirms the contracting officer's previous determination of the amount due in settlement for termination for convenience, it's the same as the date of the previous letter determination. Again, contracting officer puts out a letter saying it's agreed to a certain settlement amount, but then follows up with a formal modification. The effective date remains the date of the previous letter determination. Next slide, please. As for policy, this applies to the entire part of the FAR. Only contracting officers, quote, acting within the scope of their authority, unquote, can execute contract modifications on behalf of the government. Contracting officers, as we all know, carry warrants from the government. Those warrants describe exactly what their authority is and over which contracts. So they have to be acting within the scope of their authority to be able to sign a contract modification and an effective contract modification. This comes into play if, say, a contracting officer's representative or contracting office specialist signs a modification, but he or she does not have a warrant or is acting outside whatever authority has been delegated to that person from the contracting officer. I've seen cases where at the Board of Contract Appeals, such modifications have been deemed to be non-effective, void ab initio, as we say, because the wrong person signed the modification. Apart from the contracting officer, other government personnel may not do the following things: may not execute contract modifications, and we just discussed that, or act in such a manner as to make a contractor believe that he or she has the authority to bind the government. This comes into play in terms of discussions with a contractor, telephone calls, or even correspondence, telling the contractor that the government person has the authority to tell the contractor to do that, but the government person does not. Other government personnel also may not direct or encourage a contractor to perform work that properly should be directed through a contract modification. This comes into play when we're talking about things that arguably fall outside the scope of the existing contract, or would cause an increase in price, or added work, or adding positions to a contract, or adding a new project to the contract. Another interesting provision is the one that states that contract modifications should be priced before execution if there's no adverse effect on the government, or if a significant cost increase could result and time does not permit, at least the ceiling price shall be negotiated unless impractical. Now, in my opinion, that last phrase is paradoxical at the very least. The regulation directs the contracting officer through the word shall. We can discuss all day what shall means compared to the word will, but it directs the contracting officer to negotiate a price for a modification before executing the modification, unless it's impractical. Well, that brings up, in my mind, the question of what actually is impractical. I have yet to find a good definition for impractical, and there's really no good answer to that question. Next slide, please. So we talked a little bit, or just listed the two types of contract modifications. The first is a bilateral modification or supplemental agreement. It must be signed by both the contracting officer and the contractor to be effective. And these are used to make negotiated equitable adjustments resulting from a change order. It's used to definitize letter contracts, and it's used to reflect other agreements of the parties that modify the terms of the contract. So this is pretty broad and wide-ranging. Usually, anything that both the contracting officer and the contractor sign can be deemed a bilateral modification that both parties have come to an agreement upon. And there's usually not very much controversy here, because the parties have agreed to whatever change or modification is being made to the contract. Unilateral modifications are signed by the contracting officer only, and they're used for the most part to make administrative changes. Contracting officer is leaving for a new assignment, they're assigning a new contracting officer to the contract. Contracting office's address has changed, they're making a change to that. There's a change in the email to which contractors to send invoices. Those are usually very non-controversial. No one's really going to argue about things like that. They're also sometimes used to issue change orders, and that's where the controversy can arise. Change orders, as we'll discuss a little further on, are really designed to direct changes within the scope of the contract. Things like where the contractor is to perform, whether it's at the contractor site, a government site, or these days, in the days of COVID, at a remote site. That change order might authorize a contractor to perform work or have its employees perform work from home. We sometimes run into controversies regarding what actually is within the scope of the contract, but the body of law generally sustains changes that are in the types of things that I just described: times, places of performance, things like that. They can also be used, unilateral modifications can also be used to make changes authorized by clauses other than a changes clause. For example, property options, suspension of work clauses. And sometimes there are controversies arising from the use of change orders to affect those types of changes in the contract. Generally, most controversies arise, as you might expect, from changes that force a contractor to expend or incur more costs, and hopefully those are handled through requests for equitable adjustment. Next slide, please. So if a contractor believes that the government has effected a change that is not in writing, in other words, the contract officer got on the phone and told the contractor to do something, or that the government wanted something changed, and it wasn't in writing, the contractor needs to notify the contracting officer as soon as possible. The contracting officer then can either confirm that it is a change and direct the contractor to continue performance, and the regulation requires the contracting officer to then plan for funding that change. If there's a change in the incurred cost the contractor is going to have due to the change, the contracting officer can countermand the alleged change. In other words, let's say it came from a contracting officer's representative, and the phone call did not represent or reflect what the contracting officer that directed the COR to do, or for some other reason, it just wasn't what the contracting officer wanted. Or the contracting officer, in some cases, realizes a little bit late that what he or she is trying to do runs counter to the regulation, and decides, well, whoops, I can't do that. Or it can notify the contractor that the government believes no change has occurred. And this arises in cases where there's some nuanced change that the government has made, that it can't see how that change can force the contractor to incur more cost, or even make a slight change in the contract. FAR Clause 52-243-7, notification of changes, incorporates the substance of this FAR provision at 43-104, and generally is incorporated in any contract over $1 million. Next slide, please. Subpart 43.105 covers the availability of funds, and it basically prohibits a contracting officer from executing a modification that causes or will cause an increase in funds without having first obtained a certification of fund availability, except for modifications to certain contracts. And those are contracts that are conditioned on the availability of funds, and that's covered in FAR 32.703-2. Necessary for normal operations, Congress previously approved the funds, and certain IDIQ contracts. Also, the exception applies to contracts that contain a limitation of cost or funds clause. And you can look at FAR 32.704 for a longer explanation of limitation of cost or funds clauses. And those clauses require a contractor approaching the estimated cost of the contract to notify the contracting officer. I think we're all familiar with this. Mostly it's stated as 75% of the funds available. If the contractor is approaching that amount, the limitation of funds or limitation of cost clause would require the contractor to notify the contracting office that they're approaching that limit. The contracting officer can authorize funding increases and then go back and ensure the availability of funds. So the contracting officer has some flexibility on that ground. But usually contracting officers will know well in advance what funds are available or what funds will become available. This comes into play usually when we have a government shutdown and the contracting officer expects new funding to be available, but just doesn't have that in writing, but needs to keep the contract being performed. The certification of fund availability that the contracting officer is required to obtain must be based on the negotiated price. So that implies, or doesn't imply, it basically states that there should be a negotiated price between the contractor and the contracting officer before there's a certification of fund availability. But if the modification is executed before an agreement on price, it can be based on the, quote, best available estimate of cost, and which usually comes pretty close to whatever the negotiated price is going to be. I've seen very few instances where the best available estimate of cost in these cases has been wildly off from the negotiated price. And usually if it is, then the negotiated price goes out the window, and either the contractor and contracting officer settle on the best available estimate of cost, or there's a claim or a dispute under the contract. Next slide, please. 43.107 directs, or actually allows, the contracting officer to insert a FAR clause 52-243-7 titled Notification of Changes in certain contracts. So it's primarily in negotiated research and development contracts. It's also found in supply contracts for the acquisition of major weapon systems or principal subsystems. But it's also included, as I said before, in most government contracts over $1 million. It cannot be used in contracts that are less than $1 million unless the contracting officer anticipates that situations could arise where the contractor may allege that the government has effected changes other than those identified as such in writing and signed by the contracting officer. In other words, in contracts in which or for contracts in which there is not a high level of trust between the contracting officer and the contractor. But I've rarely seen that clause used in smaller contracts. Next slide, please. In general, nearly all government contracts include a changes clause that permits the contracting officer to make unilateral changes in designated areas that we discussed earlier within the general scope of the contract. Again, there can be argument on a lot of sides regarding what general scope of the contract means. And he does it, or he or she does it by issuing a written change order on the SF-30, which we're all familiar with, which is the amendment of a solicitation or modification of contract, unless otherwise provided. So the contracting officer can issue a change order on an SF-30, which could look like a formal modification, or simply by a letter informing the contractor of the change. Contractor's got to continue performance of the contract as changed, but is not obligated to incur costs beyond the limitations in any limitation of cost or limitation of funds clause if the contract is cost reimbursement or incrementally funded. And again, what does it mean to incur costs? How do we negotiate all that? There are pathways for that, but that really becomes the nub. Are you incurring costs, and how do you negotiate a price increase with the government for that change or modification. The contracting officer can issue a change order by electronic means without an SF-30 if there are unusual or urgent circumstances. So you could get a change order by email from the contractor or from the contracting officer. Next slide, please. So what do those changes clauses do? They're at 52.243-1 through -5. Well, depending on the type of contract, between fixed price, T&M labor hour, or cost reimbursement, contracting officer can at any time, by written order, make changes within the general scope of the contract. And by written order means by SF-30, by formal letter, by email. And the designated areas are, depending on the type of contract, drawings, designs, or specifications. This generally comes up in architect and engineer contracts, construction contracts, that type of thing. The method of shipping or packing, this generally has to do with how supplies are shipped to the government. The government can, for example, direct a contractor to use the Postal Service rather than UPS, or vice versa, or DHL, or some other air freight company if it's overseas or needs to go by air. The place of delivery, inspection, or acceptance. This generally has to do with a change in address of the contracting office or the program office to which a contractor is delivering services or supplies. A description of the services. This sometimes is where a lot of controversy arises. Description of services, that would be a change order, could be as small as requiring a contracting officer to, or requiring a contractor to use one type of software development method over another, but it probably would not be suitable to, adding or subtracting positions from a contract. Can also be used to change the time of performance. In other words, your hours are now 8 to 4 rather than 9 to 5, or inserting or deleting a holiday from the contract. Place of performance. This is tied to place of delivery, inspection, or acceptance. For example, performing work remotely, performing work at a contractor site versus a government site, etc. Place of origin. This generally has to do with supplies. Contracting officer might require a contractor to get bottled water from one source rather than another, from one country rather than another. Tonnage to be shipped. I haven't seen a lot of that, but I don't practice in that area very much. But this would have to do with how much material is going to be delivered to the government. In my mind, it seems that, yeah, the government can probably unilaterally say, no, we really need 3 tons of material versus 2. But I think common sense tells us that would require the contractor to incur costs, and I would expect a contractor, in that case, to request an equitable adjustment. The amount of government furnished property, this generally is non-controversial. The government usually goes up on this rather than down in terms of number of desks or laptops or mobile phones, if it has chosen to provide that type of equipment to the contractor. The method or manner of performance of the work. This is closely tied to time of performance and place of performance. The government really can't tell the contractor exactly how it directs its employees to do the work under the contract. The contractor is responsible for that. The government really can't tell you, apart from things like dress code, maybe, how your employees are supposed to dress while they're on a government site, etc. Directing acceleration in the performance of the work. Again, in most contracts, this is going to result in the contractor incurring cost. In some contracts, it might not. It's just, the contractor was working to the government schedule. The government actually wants a deliverable sooner than the contract currently states, but it's really, no big deal to the contractor to provide that deliverable sooner. For example, if it already has it on the shelf. Next slide, please. And this is really the nub of it. What, if any, such change causes an increase or decrease in the estimated cost or the time required to perform any part of the work? Well, the regulation requires, again through the word shall, the contracting officer to make an equitable adjustment in any one of these areas: estimated cost, delivery or completion schedule, amount of any fixed fee, the ceiling price, the hourly rates, or other affected terms. And it also directs the contracting officer to modify the contract accordingly. And these, unless the contracting officer is already inserted, or there's been a negotiated price increase prior to the modification being issued, and the modification reflects that increase in costs, contractor must, or can, it's at the contracting officer's election to request an equitable adjustment. But that's got to be submitted within 30 days of the change, depending on the specific changes clause in the contract. If there's no agreement on that request for equitable adjustment, the contractor can then file a claim under the contract's disputes clause. And what happens generally is there's a negotiated price before the modification is issued. If there isn't, or there just hasn't been time to do that, the contractor submits a request for equitable adjustment. The parties negotiate. They come up with a mutually agreeable figure, and then the contracting officer modifies the contract again after a supplemental agreement, which is the agreement by the parties to whatever the equitable adjustment is going to be. The contracting officer then issues a new modification that reflects that supplemental agreement the parties have made. If that doesn't work, the contractor can file a claim under the disputes clause. The contracting officer has to make a decision on that claim within a specified period of time. And if the contracting officer does not, the contractor can then bring the matter before the board, generally before the Board of Contract Appeals. It's important to keep in mind that equitable adjustments can be made in price or anything else, up or down. If the contracting officer has eliminated certain positions from the contract, and it's a time and materials contract or labor hours contract, or even a fixed fee, the contracting officer can then say, look, you're not providing all the positions that were in the original contract because for whatever reason, we don't need those positions anymore. We're going to negotiate the price of the contract downward. Next slide, please. Change orders have to be issued by a contracting officer unless that authority has been delegated to an administrative contracting officer. An administrative contracting officer generally is one who has some authority over multiple contracts across agencies. And this almost always comes into play only in the case of a novation or change of name agreements under FAR Part 42. And in a novation or change of name agreement, a company is asking the government to transfer its existing contract or contracts to someone else. This occurs when there's a sale of the company, an asset sale of the company's assets to another company, and the contract will then be performed by a different company with a different name, or the company itself is simply changing its name. There's got to be a modification to the contract that reflects that change in name, or the new company that's going to be performing the work. If the company has sold or transferred multiple contracts, that run across agencies, for example, DOD, DOL, GSA, then FAR Part 42 directs the novation or change of name agreement to be addressed to the administrative contracting officer. In other words, the one who holds the largest contract in terms of either sheer price or volume of work or of funds remaining on the contract. We won't get into the details of that, but just an administrative contracting officer usually is only one that is recognized in novation or change of name agreements and has authority over multiple contracts over or across several agencies, more than one agency. Next slide, please. Subpart 43.203 requires contracting officers to advise contractors of the possible need to revise their accounting procedures to segregate costs associated with any change. Segregable costs include non-recurring costs, engineering costs, costs of obsolete or reperformed work, the costs of added distinct work caused by the change order. Contractor has directed the contracting officer directed the contractor to use an additional subcontractor or order new prototypes or new retrofit or backfit kits, and the cost of reoccurring work, usually labor and material costs. A lot of smaller contractors don't have the accounting back office ability to segregate costs. At least this has been true in the past. This is becoming less true now and in the future, with more sophisticated accounting software being available to even the smallest of contractors. But there's no provision here for what happens if the contractor cannot segregate such costs. I really haven't seen a situation arise where the contractor can't in some way at least identify costs that are specifically identified with whatever change the government has ordered. So it really hasn't become an issue, and I think it's going to become less of an issue in the future. Next slide, please. As any good government regulation, this subpart of the or this part of the FAR talks about how you administer documentation. Your change orders are not forward priced. In other words, we don't know. We haven't negotiated at the time of the execution of the contract itself what prices are going to be for certain types of changes that are anticipated. Then two documents are required: the change order and the supplemental agreement reflecting the equitable adjustment required for the costs incurred by that change order. If it's an administrative or unilateral change, it initially requires only the change order. In other words, the contracting officer's name has changed, it just requires a change order. The regulation requires that these supplemental agreements, usually equitable adjustments, be definitized, negotiated in the shortest possible time, and requires the contracting officer to do several things, including establish a suspense system, perform cost analyses, develop lists of significant contract events to aid in reviewing requests for equitable adjustment. Sometimes contracting officers do this, and sometimes they don't. It also requires these equitable adjustments to be complete and final. It requires the contracting officer to ensure that all elements of the equitable adjustment have been presented and resolved, and to include those in the supplemental agreement, or include in the supplemental agreement a release from the contractor. And this is language along the lines of, we the contractor have negotiated this with the government in good faith, and we have come to this resolution, and we have no further claim on the government regarding this matter. Next slide, please. Subpart 43.205 prescribes the specific FAR clauses and alternates for different types of contracts. -1 is for fixed price contracts. It has several alternates. -2 for cost reimbursement contracts. It has several alternates. -3 for time and materials or labor hours contracts. -4 for construction contracts. -5 for construction contracts that are under the simplified acquisition threshold, which generally is $250,000, but there are some exceptions there. -6 requires the contractor to segregate costs related to changes. It's usually used in contracts of significant technical complexity, or if numerous changes are anticipated, or if deemed appropriate by the contracting officer. So he or she can stick that into just about any contract that he or she chooses. Next slide, please. Subpart 43.301 directs the use of forms. The SF30 must be used for any amendment to a solicitation, any change order that's issued under the contract's changes clause, any other unilateral contract modification issued under a contract clause authorizing such modification without the consent of the contractor, for example, property clause, things like that, administrative changes, supplemental agreements, the removal, the reinstatement, or addition of funds to the contracts, to a contract. So that's what the regulation says the SF30 must be used for. But as we saw earlier, the regulation also allows the contracting officer to make certain changes simply in writing or via electronic means without an SF30 in certain circumstances. The regulation allows the contracting officer to use the SF30. It doesn't require, it just allows for modifications that change the price of contracts for the acquisition of petroleum as a result of an economic price adjustment. And this usually has to do with FBOs at airports where government aircraft go in and get refueled. It's not necessary to use an SF30 to change the price that the government's going to pay for that aviation fuel, because it changes on a nearly daily basis anyway. It can be used for termination notices. So, in other words, in lieu of issuing an SF30 saying that the government intends to terminate a contract, the contracting officer can simply send the contractor a letter saying that it intends to terminate the contract, whether from default or convenience, and then follow up with an SF30 later, formalizing the termination. It can also be used for certain purchase order modifications. And there's really no good definition of this, but usually this is used when buying computers on a fairly small scale, and the contracting officer wants to change 20 laptops to 21 laptops. The contracting officer can do that in writing, in a letter or an email to the contractor. Next slide, please. So in summary, contract changes can be made through formal modifications or through change orders. Change orders only if it's within the general scope. The contracting and modifications can be unilateral or bilateral. Contracting officers must comply with the requirements of FAR Part 43 when issuing modifications or change orders, unless there's an exception. If a modification or a change causes an increase in price, the contractor should promptly file a request for equitable adjustment. You've got 30 days. Excuse me. If a modification or change causes a decrease in price, the contracting officer generally will calculate what that decrease should be and then negotiate that with the contractor. If the contractor and the contracting officer cannot agree on an equitable adjustment, either upwards or downwards, the contractor can file a formal claim under the contract's disputes clause, which is at FAR well, which is discussed at FAR provision 33.215, and the clause you'll see in your contracts is FAR 52.233-1. Next slide, please. So I thank you very much for joining us. I'm sorry we don't have wherewithal to take questions, but you can always shoot me an email or give me a call at that number, and I can answer any questions you have from today's presentation. Colton, I'll turn it over to you.
Thank you for a great presentation, OJ. And to our audience members, we thank you again for participating with us. If you have questions about this part, please contact our speaker with the contact information seen on your screen. And if you have any questions about federal contracting or need assistance with any of our services, please contact us directly. Thank you again for joining us. This concludes today's webinar.